Genuine assent. Now let's look at the second portion of chapter 13 with genuine assent. This is our third element of the contract, and another one that I have below our dotted line. The offeror offers to sell me their textbook for $50. They said that they had it in legal environment last semester. I accept. We're going to assume that we're both competent. Now we're going to look at whether or not we have genuine assent. What does this mean? Genuine assent is whether or not we were agreeing upon the same thing. Was my idea of what I was getting in this textbook the same as what you intended when you sold it to me? One of the ways to get at genuine assent and to make sure that you're getting what you intended is that you need to ask questions, right? So for instance, with the textbook scenario, you're going to ask, well, what edition is the book? What's the full title? And you'd want to compare the title and edition of the book that the offeror is offering to the one that's written in your syllabus. And if you really wanted to be vigilant, you'd say, well, let me thumb through the book first. So you say it's the right textbook, well, let me see what condition it's in. Are all the pages there? Have you highlighted excessively to the point that it's distracting and I wouldn't want the book? When you take those steps, you're trying to ensure that you're getting what you thought you were bargaining for so that you would have genuine assent. Sometimes people lack genuine assent because they lack the mental ability to understand what's going on. They don't know to ask the questions we just talked about. They don't have the ability to ask the questions. That would be a type of factual incapacity. So when we talk about the overall ability to enter the contract, you could lack the ability to enter a contract due to your status, i.e. being a minor. Because you're underage, the law has pre-decided that you don't have the ability to understand a contract and you're not mature enough to enter one, even though individually you might actually be mature enough. Factual incapacity applies in a situation where you're part of the general public. Generally speaking, the law presumes you have capacity to enter a contract, but you in particular are suffering from something in particular that makes you incapable of understanding. Mental incompetence is one of the primary factual incapacity states that we would think of. Here, a person might, lack mental acuity due to age, due to disease, due to, just their development. And if that person enters a contract, they accept the offer to buy the textbook. And from the offeror's standpoint, they don't realize that they were dealing with someone who lacked capacity. And they go ahead and sell them the book, right? We've got the binding agreement. But then later, a guardian or someone helping the incompetent person realizes that the incompetent person, for instance, spent their last $50 and they have no more money, or maybe they bought the textbook from the offeror and they already have the textbook. An example that, gosh, they really didn't know what they were doing. They didn't realize they already have this book. They don't need that book. Then if that offeree could show that they lacked mental capacity at the time they entered the contract, they could avoid the contract. They could undo the contract. They could get their money back and get the book back. Now, I'm using the example of the offeree, but it could also be the offeror. Maybe the offeror lacked capacity and they sold a textbook that they literally had just bought and that they need themselves. And they just weren't with it and didn't realize what they were doing. If they could prove at the time that they entered the contract that they had a mental issue that affected them to the point that they did not realize the consequences of the contract, then that would be grounds to set aside the contract. And so what I want you to keep thinking about is when we're looking at elements 2 through 6 of the contract, They're being used typically to get a party out of an otherwise valid contract. And as it relates to a mentally incompetent person, if the person has a guardian appointed for them who's supposed to be empowered and is the person who's supposed to work on behalf of the incompetent person and enter contracts for them, if you're dealing with their guardian, the guardian can validly enter into a contract on behalf of the incompetent. Conversely, if a person has a guardian and because they need one, they're incompetent, and they enter a contract without the guardian can come in and set aside the contract. Intoxication. Can being drunk get you out of a contract? Does intoxication rise to the level of a lack of contractual capacity? Well, the answer here is maybe and or sometimes. In order for intoxication to rise to the level that you would not be held responsible for a contract that you entered, yeah, it has to be a very, very high level. You have to be intoxicated to the point that you don't understand that a contract is being made. It's not that you were intoxicated so you made a bad decision, because that can happen a lot and does happen a lot. It has to be that you were so intoxicated that you didn't know that you had paper and pen and that you were agreeing to something. Not that, oh my gosh, why did I agree to do that? I'd had too many. So it's a high bar. If a party can prove at the time they entered a contract that they were so intoxicated that they lacked the ability to understand that a contract was actually being made, then they might be able to get out of the contract. The key is that the intoxication and the incompetency and even the status of being a minor have to all take place at the time the contract was entered. What about if we make a mistake? This probably happens more often than the previous examples, right? What if we make a mistake? Well, it depends upon who makes the mistake. If it's a unilateral mistake, i.e. a mistake made by one party, then you are not going to be able to get out of the contract. For example, if the classmate offers to sell you a business law textbook for $50 and you did not ask or check or inquire as to what edition it is, you assumed because they said that they'd had the class spring 2020 that they would have the most recent textbook, and you purchased it, and then you find out, oh, this is why the book is only $50. They sold me the 22nd edition, but my class is using the 23rd edition. That would be a unilateral mistake. And in that situation, you would not be able to get out of the contract because that's a mistake made by one party and it's at no fault of the other person's. Now, if you could somehow prove that the so-called innocent party knew that you were making a mistake, they knew you thought it was the current edition, and they didn't say anything about it, then you might be able to find a more sympathetic court who would help you get out of the contract. But how you prove that may be difficult because it can be hard to prove what someone else knew. You would need some evidence that they knew. How would we get that evidence? Through our methods of discovery, right? Remember those interrogatories, requests for documents, depositions, and also like if you had recordings and other types of evidence to show that they knew. But otherwise, a mistake made by one party, a unilateral mistake, will not undo a contract. But a mutual mistake, a mistake made by both parties, or if we have more than two parties, by all the parties, that may be severe enough to get the whole contract unwound. If this classmate thought they were selling you the right edition for your class of the textbook, and you thought you were getting the right book. Then you find out, oh no, this is not the edition. Maybe the professor has changed. We've got a new edition. And so you were both mistaken. In that situation, you'd have a mutual mistake, and a court might set aside, allow you to avoid the contract. Now, I'm going to make a point here. Given the scenario that I'm using, the textbook, right, we wouldn't go to court. Like, nobody's going to go to court for a $50 textbook. And these are the rules, the law that governs if you go to court. In real life, even with a unilateral mistake, if you talk to the person who sold you the book and say, hey, when you offered me the textbook, I thought it was the right edition for my class. I found out it wasn't. Can I get my money back? The person who sold you the book, the offeror, can always agree to do so. Even though the law does not require them to do so, they can decide, well, it just makes sense. We're here in school together. Why am I going to take advantage of you? It was an honest mistake. Here's your $50 back. I'll take the book back. But what this law lets you know is that legally that person would not have to give you your money back. If you wanted to take the time, effort, and expense to sue them, and it was a unilateral mistake, you would probably lose the case. But people are always free to be more generous and be more conciliatory than the law requires. Remember, we talked about that in our chapter 1. The law doesn't govern all moral conduct. It's like a floor on what's wrong, what's illegal. But people can do lots of other things, make other decisions that the law does not require. And so the offeror could take the book back even though it's a unilateral mistake. And then when it's a mutual mistake, you don't have to go to court. If you both realize you made a mistake, you could just unwind the deal yourselves. This is a law that applies if you can't agree. But what if we have an intentional misrepresentation? The person selling you the textbook for $50 knows that's not the right edition, and they're just hoping to get your $50 before you find out, right? In that case, you could take the person to court. Intentional misrepresentation may be difficult to prove, but whether or not you can prove it is a factual issue that you will uncover during discovery. What we're talking about now is legally, do you have an action? Can you take them to court? Yes, for intentional misrepresentation. Then whether or not you have the facts to prove it comes after the fact. And you find that out during discovery. We can also have a lack of genuine assent due to fraud. Fraud is very similar to negligent misrepresentation, but it's more severe, and typically if you can't prove the elements of fraud, or you can't allege all the elements of fraud, you would fall back on the negligent misrepresentation. So they're very similar. But with fraud, you have to have 4 specific things. First, you have to have a material misrepresentation of fact with knowledge that that fact is false, or it's made with reckless indifference to the truth. You must have the intent that the listener rely on the misrepresentation. The listener does rely, and as a result, the listener is harmed. What does all this mean? So let's look at our car transaction again. The used car salesperson is selling you a Honda Accord. They tell you that this is one of the best cars on the road. You buy the car based upon that representation, and within a week, the car is breaking down, it's sputtering, and you take it back and you say, guess what? I'm suing you because this certainly isn't the best car on the road. Are you going to get anywhere with that? Probably not. Why not? Because the statement, this is the best car on the road, is an opinion. It's definitely not a fact. So even though it may have been a misrepresentation, that car might have been beat up and had engine problems and the salesperson knew it, the statement that they made that you're relying upon was not one of fact. So you first have to have a material misrepresentation of fact. Material means significant, like it has to be something that significantly impacts the transaction. Misrepresentation means it's false, or we're going to talk about it was made with reckless indifference. It's got to be a fact, something objective. So if the salesperson said, this Honda Accord only has 13,000 miles on it, and then you purchase the car and you take it to be worked on, and they were able to uncover that based upon the VIN number of the car, the odometer is registered, it had been turned back, and the car really had 75,000 miles. That would be a misrepresentation of fact. Or the salesperson tells you that the car had a V8 engine, and you find out it really had a V6 engine. That would be a misrepresentation of fact. Now, the first element, because you have to have a misrepresentation of fact, and then the person making the statement, i.e. the salesperson in this case, has to either know that what they're saying is false, or they're making the statement with reckless indifference to the truth. Now, everybody pretty much understands what it means to make a statement knowing it's false. In other words, you know that what you're saying is not true when you say it. We call that a lie in layman's terms. If what you are saying is not true and you know it's not true, that's making a misrepresentation of fact with knowledge that it is false. The second piece of this is what gives people trouble. Or if you make a false statement with reckless indifference to the truth. I would argue a lot of people do this. Reckless indifference to the truth is you say something that is not true, and you do not know whether or not what you're saying is true, but you say it anyway. So I'm going to say that again. You can have the first element of fraud if you have a misrepresentation of fact, i.e. something that's not true, a lie, and you state it with reckless indifference to the truth. So you make a misstatement of fact and you don't know whether it's true or not, but you say it anyway. The car salesman example is a great context for this, because when you go to used car salesmen, they have a reputation, right, of they'll say anything to get you to buy the car. And that may include telling you that the car is in good working condition, whether or not they know it to be true. That can be fraud. People sometimes have this misconception that if I say something that's not true, but I don't know that I'm lying, then it's okay. A lot of our politicians do that too. They make statements that are false, completely false. And then when they're caught in it, they say, oh, well, I didn't know it wasn't true. Well, it is fraud if you knew that you did not know whether or not what you were saying was true. And then you also had this element that you expected people to rely upon what you were saying. They do rely, and then they suffer harm. So let's look at that again. If the speaker, the person we're going to allege who's committed fraud, makes a misstatement of fact, they know what they're saying is false, and they're saying it because they want the other person to rely on this misrepresentation. The listener does rely, i.e. they buy the car, and then they are harmed, and harm can be monetary or physical. Usually when we're looking at fraud, a lot of times it's pecuniary loss, like I paid too much for the car, or I paid for something that was fake, or this was I should have paid $200 for it, and instead I paid $2,000. If the listener was harmed based upon this misrepresentation of fact, that is fraud. But also, if the speaker makes a material misrepresentation of fact and they do not know if what they're saying is accurate, but they're saying it because they want the listener to rely upon it, i.e. I want you to buy the car. and then you do rely on what I said, you buy the car, and then as a result, you get a car that's worthless. That is also fraud. Many students have trouble with this every year. Reckless indifference is when you say the car has brand new brakes, but you as a salesperson have no idea whether or not the car has new brakes. You might be assuming it has new brakes. You might believe it has new brakes. You might even want it to have new brakes. But if you, the salesperson, don't know for a fact that it has new brakes, and you tell the purchaser the car has new brakes, and then based upon that statement, they rely upon what you said about this car and they buy it, and then their brakes fail because it turns out that they were not new, they needed replacement. That statement that you made where you were not sure whether or not the car had new brakes, that becomes fraud. And I'm going to reiterate that the reckless indifference piece is what gives people trouble because they think it's a mistake. And to make a false statement with reckless indifference to the truth is not a mistake. A mistake is when you genuinely think that the car has new brakes because maybe you saw the car in the automotive part of the dealership being worked on. Maybe you saw the purchase order for the brakes for that particular Honda that's on the lot. Maybe the salesperson heard the manager talking about we're getting the brakes fixed on that Honda. And then because of that information, the salesperson reasonably believes that the car has new brakes. So they are mistaken. That could be a mistake. But when the salesperson has no knowledge upon which to make their statement, they just know, well, this potential buyer wants to know, does the car have new brakes? They ask me, hey, does this, 98 Honda, it's pretty old, does it have new brakes? And the salesperson says, yeah, of course it does. And they don't even know if that's true or not. That is a misrepresentation of fact because that's something objective that is either true or not. And even though the salesperson didn't know that what they were saying was false, they said the statement knowing that they didn't have any idea whether it was true or not. So they were making a misstatement, a fact with reckless indifference to the truth. And then if the buyer relies on that statement and they suffer harm, which the law will say they don't have to be physically harmed, just the fact that you paid for something that's not what you thought it was is harm. That's pecuniary loss, financial loss. If you have all four of those elements, you can allege fraud against the other party. Now, what's the value of this? Let's relate it back. We already have a valid contract. The salesperson offered to sell you this used Honda Accord. Let's say it was cheap, it was like $5,000 for this used car. You accept the deal, you buy it, you get the car home, and the brakes fail the first day. When you decide to pursue a case, when the salesman says, hey, we got a valid contract, what's the deal? Sorry, it's not what sorry the car broke down. Cars break down. I can't ensure its safety. In this scenario, our buyer would say, no, wait a minute. Yeah, you can't ensure its safety generally, but you expressly told me that the brakes were new. And you either knew what you were saying was false or you made it with reckless indifference to the truth. With the intent that I would rely upon it and buy the car, I did buy the car. And as a result, I overpaid for this car that has faulty brakes. That is fraud. Fraud is difficult to prove, which is why we have this related concept of negligent misrepresentation. If you can't plead all the elements of fraud, like you can't prove that the person knew that the statement was false or that they acted with reckless indifference because they keep claiming they didn't know, then you can use negligent misrepresentation. Typically, in cases when you see plaintiffs or defendants alleging that that fraud was committed, we will also include negligent misrepresentation, because in real life you don't just put in one cause of action. You put in all the ones that the facts would could reliably go towards. Like, so you have more shots at the at the bullseye, for example. So you have more opportunities to possibly win. So based upon these facts, I could get fraud or I could get negligent misrepresentation. One of these ought to work. If I can't prove all the elements of fraud, I can at least prove that, well, you should have known that the brakes are faulty, even though you didn't, and therefore get out of the contract. And again, this is under our little dotted line. If you knew fraud was taking place at the time you were entering the contract, you wouldn't enter it, right? So whether or not you have a lack of genuine assent based upon fraud is not going to surface until after the contract has been made. And this is a vehicle that a party could use to get out of an otherwise valid contract. Our last manner of lacking genuine assent that we'll cover in this chapter, because there were more methods covered in your book, but these are the only ones that we're going to discuss, are undue influence and duress. These are very related. Essentially, what a party would be arguing is, yes, I agreed to this contract, but I wasn't really on the same page. I wasn't agreeing to the terms of this contract out of my free will. It's because the other party was putting pressure on me. They were pressuring me, be it economically or with threat of violence, and so I had to agree to these terms. So this is another method that a party could use to get out of an otherwise valid contract.